Hi, welcome to our new podcast series, Elevating Corporate Safety. My name is Rebecca Wormleighton. I'm the COO and co-founder of Zendelity. Our goal with this series is to bring together industry experts to help businesses rethink their operating strategies, to embrace innovation, and build a strong case for prioritizing safety. Joining me today is Andrew Soto. Andrew is one of this year's top 25 under 40 for safety, an impressive accomplishment. So Andrew, welcome to today's discussion. If you could take a few minutes, introduce yourself, maybe tell us a little bit about some of your great accomplishments this year, because there have been many.
Thank you so much, Rebecca. I'm Andrew Soto. I'm an award-winning health and safety professional with over 13 years experience in industrial construction and commercial real estate. I was lucky enough this year to win OH&S Canada Top 25 Under 40 and BOMA Edmonton's Emerging Leader Award.
That's fantastic. Congratulations. That's impressive and well-deserved. So again, thank you for joining us today. And for sharing your insights. As discussed today, we're hoping to pick your brain about safety, due diligence, and the truth about occupational health and safety court. 'Cause I think a lot of people don't really understand what it is we're actually talking about. So maybe we can take a minute and let's start with just explaining due diligence. When you think of, for the owners and the operators of businesses out there today, what is due diligence? What does it really mean?
Yeah, due diligence is a big and scary word. Basically, it means that you've demonstrated your actions before an incident and not after. Applied to OH&S in Canada, due diligence means that an employer shall take all reasonable precautions under particular circumstances to prevent injuries or accidents in the workplace.
Fair enough. And I just, so if you were to guess how many pages or how thick is the health and safety manual that's explaining what's involved in due diligence and all the things that you need to do? Could you put a size or a scope around that for people to understand?
Well, in Alberta, the OH&S book is probably 2.5 inches thick. So it's a lot that goes into due diligence, and it's all about doing everything that you can that is reasonable and practical.
Absolutely. And how often, in your experience, you've been at this for 13 years, how often are you seeing those regulations or those requirements changing? That
For the criminal code or the OH&S side of it?
well, you know what? Let both.
The criminal code actually was updated, I think, in 2004. Actually, let me go back on that one because I do want to fact check myself on that.
No, please.
Yeah, let me one sec. I got it on one of my PowerPoints that I built. It was 92 that the West Ray mine disaster happened in 2003 when the Bill C-45 received royal assent.
And that bill, what does that mean? What is that bill?
Bill C-45 was put in place to essentially remove the I don't know excuse from management and supervision. Essentially, that established a duty in criminal law to protect the health and safety of everyone in the workplace.
Interesting. Okay. So what did removing the I don't know clause, what was the implications of that?
Well, that basically means, and the criminal code does now state, everyone who undertakes or has the authority to direct how another person does work or performs a task is under a legal duty to take reasonable steps to prevent bodily harm to that person or any other person arising from that work or task. Meaning, if you give direction to somebody, it needs to be proper direction. If you give somebody direction and they get hurt, you are now liable under the criminal code. And in Ontario, that could be up to a $500,000 fine for individuals and up to 12 months imprisonment. For corporations, that can go up to $2 million in fines.
Wow. And for me, I think the point is, and what we've got to take away and remember from this is that it's all about being personally liable. right?
Absolutely.
And that I think is the change that people need to understand from that conversation is it's no longer our ability to hide. We are personally liable for the actions and the activities or the decisions that we make, which is different, right? Like, so
It is.
we used to be able to hide.
It actually
Fascinating.
chases it all the way up to the CEO. If they find fault all the way up to the C-suite, the executives can actually be imprisoned as well.
So when you say fine fault, so when if the CEO knew that this is happening, so would it be each level within the org, like, so if I'm the manager and then my director and then my VP and then my CEO, if they all knew
Everybody's
that
liable.
everybody would be held liable. Yeah,
Everybody
fascinating.
would. The person that would be directing the work, and let's say that they intentionally didn't get a piece of safety equipment, like a trench box for an excavation.
Mhm.
If they knowingly didn't put that in place and somebody died in that excavation, yes, that can go all the way up the chain to the C-suite and the executive level.
Fascinating, fascinating. And yeah. And how many people do you think really understand that? Do you think that's widely understood, or do you think people are largely still under the impression that
People don't know about this from my experience. Whenever I've brought it up, it honestly scares people. It's one of those things that you don't know what you don't know, and you don't find out about these kind of things until it's too late and you're in a very bad spot. That's why it's very beneficial for companies to invest in a safety program and have the resources to put towards creating a good safety program, giving the company and the people the resources they need for training, personal protective equipment, and many other things that come into play for a safety program.
absolutely, absolutely. Okay, so we know if something goes dearly wrong, we're personally going to be held personally liable. But let's talk a little bit about what it actually means when we have an incident and we have to go to occupational health and safety court. Can you paint a bit of a picture for that for us?
Absolutely. So OH&S court works differently than other courts by actually presuming you're guilty first rather than innocent. Criminal court in Canada presumes you're innocent until proven guilty. OH&S court does not work like that. It's up to you to prove your innocence once you're charged by presenting your strong due diligence case. If you can't produce evidence to prove your innocence, then you will be found guilty and charged criminally under the criminal code. Due diligence involves showing that an employer or an individual took all reasonable precautions to prevent the incident. This includes implementing safety protocols, providing adequate training, and ensuring compliance with safety regulations.
So if you have a fire and your, last 3 months of inspections for your fire extinguishers haven't been done and the fire extinguisher doesn't work, is your,
You may be held liable depending on the severity of the incident. It's all subjective to the OH&S officer, depending on what they want to charge you with. They can charge you under the OH&S Act, or they can charge you criminally under the criminal code in Canada if it's bad enough.
interesting. Okay. Okay. Um, so let's talk about something, when something does go wrong. Let's talk about, from that moment of something going wrong through to that journey of, court and the like. Can you talk us through in your experience what that looks like, what to expect?
Absolutely. So the second somebody gets hurt or you have a fatal incident, the first thing you need to do is get an immediate response. Firstly, get medical attention for that injured worker and secure the scene so that we're not leaving hazards out there or anything else that could potentially hurt somebody. Securing the scene is very important. It's actually required for the investigation and by law, depending on serious incidents or fatalities. Then you're going to start working into incident reporting. So serious or fatal incidents need to be reported to OSHA or OH&S immediately, and then internal investigations and government investigations will start from there. From there, continuing on, it could be up to 2 years for the government to actually complete their investigation and file charges. In the meantime, you're calling legal representation and preparing your defense, gathering all of your documents and paperwork, training records, anything that that person has ever signed off on. From there come the legal and financial consequences. So there could be fines in the millions, and people could go to jail when it's all over, depending on how serious the incident is. In addition to those consequences come the potential reputational damages. We've all seen companies on the news that have hurt or killed somebody, and I think that's all a pause for the cause, and we take a moment to just reevaluate if we want to do business with that company, knowing that they hurt people or kill people.
Yeah, which brings us back. So in our earlier podcast, when we were talking about the quality of a quality safety program and, a profit center, I think you just hit it. Safety does have a direct impact on our customers and their perception of us and whether they want to spend the money. And I think it's important for organizations to consider that, it's not just of course, it's about our employees and them, them being safe, but there's a much bigger downhill effect when something does go wrong and the implications for those around. So fantastic. Now,
Absolutely.
and I think it was in our earlier podcast. So coming back to your costs, right? Like you just outlaid all the costs, legal costs, the administration for dealing with the claims and in an earlier discussion, you had used the average incident cost $10,000, but that is just what cost is that compared to like if you get into this? Because obviously that's going to be way more than $10,000 if we're going to
Of
court and
course.
we're doing so when you hear statistics and people talking about 10,000, is that really just the cost of the worker? In your experience, is that the overarching or the average, I guess, and then you've just
That
got
would be average
constraints?
for a very low level incident. That's just a paper cut, really. That's the administrative time, that's the reporting time, and sometimes the worker's rehabilitation and any lost wages. Of course, when injuries or incidents get more severe, that cost goes up significantly, and you could end up in the hundreds of thousands of dollars when it comes to this kind of thing, especially once you're calling for legal representation.
Yeah, absolutely. So for the people out there that say this isn't going to happen to me, this is an expensive risk and an expensive proposition. So thank you so much, Andrew, for taking the time to join us today and to help people understand the risks that we're actually talking about. This is much more than someone simply getting hurt. There's a huge impact to the organization, and we all need to understand what that is and the fact that we're personally liable. So thank you for taking your time. And thank you, everybody, again for joining us. Again, my name is Rebecca from Zendelity. We are empowering businesses to maintain safety and due diligence and providing you with the data to defend those claims when the time comes. So thank you for your time, and we will chat soon. Thank you.
Thank you
Bye-bye.
so much, Rebecca.
Thank you.